Good day. We are the group three. Today we will going to discuss the other part um, of the joint and solidarity obligations, which was discussed by the group uh, three previously. The first three uh, joint and solidarity obligation was discussed by the group three are the pure and conditional obligations with a period and alternative. Today we will going to discuss the other three of the kinds of obligations. These are the joint and solidary, the divisible and invisible, and with the penal code. Joint and solidary obligations. Under these discussions, we will discuss about the meaning and the difference between joint and solidary obligations. What would be the rules regarding the joint and solidary obligations? What would be the effects of this to the others when creditors remitted solidary to these debtors' debt? We are going to discuss also the effect of uh, insolvency of solidary obligations. When we say insolvency, these are the paying of debts of the solidary obligations. Okay. For the Article 1207, this discuss the solidary obligations. This article is also linked to the Article 1208. I will continue discussing the article when we get to the 1208. In 1207, it refers to the solidary obligations, while in 1208, article clearly refer to the jointly obligations. In Article 1207, as I mentioned before, this article is linked to 1207. In Article 1207, the concurrences of the two or more creditors or two or more debtors in one and the same obligation does not imply which one of the former obligation does not imply that each of the former has right to demand or each of one of the latter is bound to render entire compliance with the prestations. There is no solidary liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So, as you can see, the joint and solidarity obligation, it refers to the juridical tie of the debt and the debtors or creditors. The next is concurrences of the multiple creditors or debtors are both in one same obligations. When we say concurrences, concurrences of the multiple creditors or debtors are both in one at the same obligations. This means the subject of the rules of the court governing the multiple suit. Kasi pag joint obligation, piniprevent niya yung maraming demand involving one single cause of actions. Kunwari, maraming creditors sa isang utang. No? For example lang, utang niya is 1 million pero may 3 creditors. No? When we talk about joint and solidary obligation, there are many subjects or simply there are many creditors or debtors or both. Pero kung ganun nga, ano magiging rule? For example, si ABC may utang kay XYZ, no? As of 10,000 pesos. So anong implication nun? Later, we will discuss further with the examples for us or for you to deeply understand. For the Article 1208, if the form of the law or the nature of the wording of the obligations to which of the preceding articles refers to the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors, the creditors or debts being considered distinct from the another subject to the rules of court government of suit. So what are the difference of the solidary and joint obligation? For the solidary example, what if may three creditors, the A, B, C, and D, lahat sila may karapatan to collect or maningil the entire obligation, which is the entire 1 million pesos. Yun yung binigay kong example kanina na uh, may utang na 1 million pesos, pero may tatlong creditors. No? So, sa ABC, si A, B, and C, lahat sila may karapatan to collect at maningil the entire obligation, which is the entire 1 million. Ganun din si debtor. This time, baligtad. They have the obligations to pay. Let's say we have debtors X, Y, and Z are the solidary debtors. With regards to 1 million peso debt, so any one of them is obliged to pay the entire 1 million pesos as an obligations. However, when we talk about joint, only refer creditor or a debtor has a right of obligations to collect or pay only his share. For example, yung utang ay 900,000 tapos meron tatlong creditors. Assuming they are joint creditors. Creditors A, B, and C are joint creditors. With regards to a 900,000 peso debt, each one of them has only the right to demand their shares. Therefore, si creditor A, no, magkano ang masisingil niya? Of course, 300,000 pesos lang. No? As you can see in the PowerPoint, these are the other term for the joint and solidary term. These words can also be used, for example, in the exam. So for the joint, the other term would be the jointly, the conjoint, the mancomunada simple, the prorata, and the proportionate. While on the solidary, the other term would be the joint, and severally, in sodium, mancomunada, solidaria, juntos or separadamente, or individuality and collectivity.
So how much is B liable to pay? How much is B liable to pay? So magkano ang babayaran ni B or magkano ang amount na liable siya bayaran? So obviously, 3,000 kasi pag joint, inuulit natin, kung babalikan natin yung dalawang box na solidary and joint dito, kapag joint, sabi niya, obliged lang yung isang debtor na magbayad ng kanyang share at to extend ng kanyang share lang. So hindi siya liable na bayaran yung share ng iba. Unlike sa solidary, kapag solidary kasi, liable ka pa rin. Okay, kailangan mong bayaran kung sakaling ikaw yung siningil, hindi mong bayaran yung share ng iba. So syempre, joint lang to, so hanggang dun sa share mo lang. Napag-usapan natin na yung share nila is hanggang 3,000 lang. So syempre, ang liable si B, specifically si B na bayaran ay yung kanyang share lang, which is 3,000. So how much can Z collect? So ganun din, binanggit natin kanina na kapag joint, ang pwede lang makollect ng isang creditor ay up to extent ng kanyang share. So yung kanyang share up to 3,000. So 3,000 lang yung pwede makollect ni Zay. So tatandaan po yan. Sir, next po. So next question is, how much B liable to pay X? So this time, in-specify natin yung question. Meron tayong isang debtor at isang creditor. This time, ano kaya yung sagot? So, ayun naman, nakalagay 1K. How much B liable to pay X? In-specify natin. Kung maalala nyo, kapag ang tanong is how much B liable to pay, walang specific creditor, ang sagot ay 3,000. Kasi yun yung kanyang share. Yun yung kanyang up to extent ng kanyang share. Pero paano madidistribute yung 3,000? Yung 3,000 na yun. So ibabayad yun, simple lang. Madidistribute yung 3K sa tatlo. only 1K, um 1K kay X, 1K kay Y, 1K kay Z. So all in all, meron tayong 3,000. So next question is, sir, pabalik po. How much can Z collect from A? Nabaliktad lang yung question kanina, liable to pay, ngayon collect. Kung maalala natin, kapag ang tanong is how much can Z collect, the answer is up to extent ng kanyang share, which is 3,000. Pero this time, inuulit, nag-specify tayo ng isang creditor. So, ganun din. Si Z, pwede niya makollect from A, B, and Z. Kasi tatlo yung debtor natin, 1K each, total of 3,000. So, tama, 1K yung sagot. Next po. So, how many distinct debts are there? So, there are 9 distinct debts. So, ano yung mga yon? Ito yung mga yon. Yung obligation ni A kay X ay 1,000, and kay Y and kay Z. And so on hanggang sa 9, totaling 9,000. Kumbaga, pinag-connect or matching type A, B, C, pero dapat lahat ma-match kay X, Y, and Z. So, pag itong question, simple lang. I-multiply mo lang yung 3 by 3. So, A, B, C, tatlo sila. X, Y, and Z, tatlo din sila, equals 9. Ganun lang lagi yun. So, ganun, nakakonect sila lahat. Kasi joint sila pareho. What if naman, hindi sila joint pareho? Yung debtor joint, pero yung creditor, solidary. Next po. Yan. So, this time, hindi sila joint lahat kasi this time yung creditor solidary, binanggit solidary, so ABC are bound to pay. Sir, pa next po. Yan. Specifically binanggit solidary, so ABC are bound to pay solidary creditors. Yan, creditors X, Y, and Z ng 9,000. Si ABC ay joint pa din kasi wala namang binanggit eh. So first question tayo. Next po. Yan. How much is the share of A, B, and C in the debt? Obviously, they have 3,000 each. Parang ganun pa din this time kasi hindi naman nagbago. Join pa din sila. And the next question is, how much is the share of X, Y, and Z in the debt? 3,000 pa din. Hindi naman nabago kahit na solidary sila. Actually, tama pa din yung sagot natin. Yung sagot natin, 3,000 each. Pero hindi yung tungkol sa share. Yung solidary, yung pagiging solidary creditor, hindi yan tungkol sa share mo, okay? Ganun pa din yung share mo, pero yung pwede mo lang singilin, yung naiiba. Next po. So, how much is be liable to pay? So, meron tayong dito 3,000. Totally, hindi naman nabago, joint pa din. So, tama yung 3,000. Pero kapag binanggit dito ay kung magkanong babayaran niya, specifically sa isang dito sa next question, how much can Z collect? Okay, sabi natin inuulit kapag solidary or kapag joint to the up to the extent lang na share mo yung pwede mong makollect, so 3,000. Pag joint, yun yung isasagot natin, 3,000. Pero this time, hindi siya joint, solidary siya. Therefore, sabi natin, under solidary, pwede natin makollect or bayaran kapag in case of debtor, is the whole obligation. So 9,000, okay. Yun, tama, 9,000. Next po. So how much be liable to pay X? So naging specific na tayo. How much is be liable to pay X? Ngayon nagbanggit tayo ng specific person, pero actually it doesn't matter. Actually, kahit na nabanggit si Y or Z, dahil sa babayaran niya pa din ay ibabayad niya sa lahat ng kanyang share, which is 3,000. Kasi whether si X or whether si Y or whether si Z, meron sila lahat. Lahat sila sa pagiging solidary creditor, lahat sila pwedeng maningil lahat ng utang. Kahit utang ni A, utang ni B, or utang ni C. So lahat sila pwedeng maningil. For the last question, how much can Z collect from A? Okay, so si Say, ang pwede niya makollect ay 9,000. Pero this time, nagbanggit tayo ng specific debtor. So ang pwede niyang masingil specifically from A is 3,000 pa din. So bakit 3,000? Bakit din niya pwedeng singilin yung 9,000? Kasi malamang si A, kasi pag joint debtor, so ang pwede niya lang bayaran ay up to extent ng kanyang share. Pero hindi ibig sabihin, kino-contradict natin yung sinabi natin kanina na which is magkano ba pwede singilin ni Zay lahat-lahat. So 9,000 pa din. Kasi later on, pwede naman maningil si Zay from A and from B and C. So overall, makakakollect siya ng 9,000. So after that, si Zay, i-distribute niya yung 9,000 kay X and Y, which is magkakaroon sila ng tatlo ng 3,000. So 3,000 each yung sagot. Next po.
Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. Obviously, this is a joint indivisible obligation. The obligation is joint because the parties are merely proportionately liable, and indivisible because the object or the subject matter is not physically divisible into different parts. So joint is referring to the ties between the parties, while the indivisible refers to the object. For example, A, B, and C are jointly liable to deliver a car to D. So on the date of delivery, A and B are willing, but C is not. Since the car is indivisible, the object of the obligation is indivisible, which is the car, the debt can only be enforced only by proceeding against all the debtors for compliance. In this case, liability is converted into one for damages. Next, sir. Article 1210. For the Article 1210, the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity itself imply indivisibility. The Article 1210 talks about the indivisibility. Tapos, dinidistinguish siya kay solidarity. Sabi ng article na to, indivisibility ng obligation is hindi agad nangangahulugan ng solidary. At hindi porket indivisible ang object, solidar na. Same rule naman pagbaliktad. Ang solidary ng obligation does not itself imply indivisibility. The indivisibility and solidarity ay different. When we say indivisibility, it refers to the subject matter or the subject of the obligation. Tulad ng example dun sa Article 1209, yung subject matter nun or na object is yung car. While pag sinabing solidarity, it refers to the tie between the parties or yung connection nila. Joint and solidary obligations, kind of indivisibility. First one is the legal indivisibility. This is indivisibility which operated by law. Next one is the conventional indivisibility. This indivisibility had the agreement of the parties. And the obligation which is divisible by nature is made divisible by the will of the parties. It tells the willingness of the parties. And lastly is the solidary obligation. This obligation where each debtor is liable for the entire obligation. And yung mga creditor naman entitled sila to demand the fulfillment of the whole obligation. This refers to the vinculum or tie of a relationship existing between the parties. An obligation can be indivisible and solidary at the same time. Hence, an obligation can be solidary indivisible obligation, solidary indivisible obligation, joint indivisible obligation, and lastly is the joint divisible obligation.
Article 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. So, solidarity, despite different terms and conditions, so pwede siyang uniform when the parties are bound by the same stipulation or classes. Lahat ng part, pareho lang ng terms and condition ng kanilang obligation and rights. Pwede naman siya maging uniform or varied dito naman when the parties are not subject to same stipulations or classes. Sir, proceed na po tayo sa 12.12. Article 12.12. Article 12.12. Each one of the solidarity creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. The provision provides that solidarity creditors may be useful, not prejudicial acts. Pwede yung useful acts pero hindi yung prejudicial act. Ano nga ba yung act beneficial? Lahat ng mga creditors may perform acts that will benefit each other. Maaari nilang tulungan ang bawat isa to have more gains and build in their relationship in good standing. Example, si A ay umiram ng pera kay B at si na nagkakalagang 10K pesos kapag ang utang ay due date na at kailangan na magbayad si B at C ay pwedeng gumawa ng judicial or extrajudicial demand from A for payment of A will rebound to benefit of both B and C. Article 1213. A solidarity creditor cannot assign its rights without the consent of the others. Hindi pwedeng ipasa ng nagpautang kanyang mga karapatan kung walang pahintulot ng kasamang nagpautang. The debtor may pay any one of the solidarity creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment shall be made to him. Ang may utang ay maaaring magbayad sa sino man sa magkakasamang magpautang at ang pagbabayad kung tatanggapin sino man sa kanilang magkakasamang may pautang ay mag-aalis ng pananagutan. Example, A, B, C, D ay ang mga solidarity creditors that representing the credit union and si E ay isang may utang kung si ay umiling kay E upang matupad o magawa ang huling obligasyon. Si E ay makakapagbayad lamang kay C at ang pagbabayad na yon ay sapat o okay na para patapos ang obligasyon ni E at ng utang.
Article 1215. Novation, compensation, confusion, or remission of the debt made by any of the solidarity creditors or with any of the solidarity debtors shall extinguish the obligation without prejudice to the provision of Article 1219. Ang nagpautang ay maaaring gampanan ng alinman sa mga nasabing gawain o kaya ay kung sino man ang maniningil ng pautang ay may pananagutan sa iba para sa kanilang parte sa obligasyon na para sa kanilang lahat. Novation. Obligation is modified by one, changing object of principal obligations. Second, substituting the person of the debtor. And third, subrogating a third person in the rights of the creditor. Compensation. When two persons in their own rights become creditors and debtors of each other. Confusion of merger of rights. When the character of creditor and debtor are merged in the same person. Article 1275. Remission or condemnation. This is the gratuitous abandonment by the creditor of his right. Joint and solidary obligation. Example, D owes A and B and C solidary creditors. The 3,000, if C remitted the entire obligation without A or B consent, the obligation will still be extinguished. However, C is liable to A and B with regards to their respective shares of 1,000 pesos. Sige, sir. Article 1216. The creditor may proceed against any one of the solidary debtors or some of or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may be subsequently be directed against the others so long as the has not been fully collected. Ang nagpautang ay maaaring magtungo sa kahit kanino man sa nangutang o kahit kanino man sa kanila ng magkakasabay. Ang utos na ginawa laban sa isa sa kanila ay hindi hadlang para sa mga pagkatapos ay diretso na sa iba hanggat ang utang ay hindi pa buo na nakukuha. In a solidary obligation evidenced by a promissory, the solidary debtors were ABC. B was not sued, however, because he had died before the suit began. The other debtors then asked the estate of C be included as a party defendant. Article 1217 po, sir. Article 1217. Since payment is mode of extinguishing an obligation, payment by one of the solidary debtors extinguish the obligation in case two or more debtors offer to pay. The creditor may choose which offer to accept. After the payment of the debt by solidary debtor, he in turn becomes the creditor of his co-debtor for his shares. If a solidary debtor cannot reimburse the amount due the co-debtor who paid the debt, then all the other debtors, including the one who paid the debt, should be bear proportionately the insolvent debtor's share. Example, A, B, and C were solidary in debt to X in the amount of 10,000 pesos payable on March 30, 2016. On March 30, 2016, A paid X the whole amount of 10,000 pesos. The effect of the of past payment was to extinguish the obligation if A and B at the same time offered to pay the debt. Then it was up to X which offer to accept. If the offer of A was accepted by X, then A now become the creditor of his co-debtor. B and C, by reason of as payment, B should reimburse the A 2,000 pertaining to his share with interest. C should also reimburse his share to another 2,000 as his share also with interest. However, if C could reimburse his share to A because of C's insolvency, then B should bear 1,000 pesos by paying the same to A and later should also bear the other half of 1,000 supposing the payment of A was made before March 30, 2016. Could A demand of B and C the payment of interest? No, because no interest for the intervening period may be demanded. Example ay Article 1218. Article 1218. Payment by the solidary debtor should not entitle him to reimbursement from his co-debtor if such payment is made after the obligation has prescribed or become illegal. Ang pagbabayad ng isang solidaryong debtor o may utang ay hindi magbibigay sa kanya ng karampatang makuha muli ang binayad mula sa kanyang mga kasamang solidary debtors kung ang pagbabayad ay ginawa matapos ang takdang oras ng pagbabayad o ang obligasyon ay naging hindi legal. Example, A and B are solidarily bound to deliver medical drugs to C. The transaction of such medical drugs were later prohibited by law. Notwithstanding the prohibition of B performed the obligation by delivering the prohibited drugs, B is not anymore entitled to reimbursement from A.
Article 1218. Payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Only state na kapag nakapagbayad na ang isang solidary debtors, wala siyang karapatang kuhanin ulit ito mula sa ibang solidary debtors. If una, kung ang pagbabayad ay ginawa matapos ang takdang oras ng pagbabayad, at pangalawa naman, ang obligasyon ay naging hindi legal. So, yan. In a joint obligation, each obligor answer only for a part of the whole liability and each obligee belongs only a part of the correlative rights. Whereas in a solidary or joint and several obligation, the relationship between the active and passive subjects is so close that each of the former or of the latter may demand the fulfillment of or most comply with the whole obligation. Sa madaling salita, sa joint obligation, to each his own, while sa solidary obligation naman, one for all for one. Article 1218. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt had been totally paid by any one of them before the remission was affected. Naunang nagbayad o ginawa muna yung pagbabayad bago magkaroon ng remission or waiver. Pero ang waiver is no effect kasi nga bayad na sila. Bayad na yung naging debt. Tapos, Article 1220. The remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. So, yung remission of the whole obligation na obtained by one solidary debtors, hindi siya pwedeng mag-demand ng reimbursement from his or her co-debtors. Yung rason dito ay dahil yung debtors who obtain remission ay wala namang binayaran sa creditor. So, ibig sabihin, wala rin siyang rights na mag-demand or humingi ng reimbursement sa katulad niyang debtors. So, yung remission doon ay walang batayan.
Okay, for the Article 1221, if the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. In this first paragraph, when the loss and impossibility is without the fault, no liability siya to other obligation is extinguished. On the second paragraph naman, meaning to say, if may fault sa debtor, then there is a liability plus damage and interest. While on the paragraph 3, it means pag yung the loss daw is because a frustration under a frustration event after the default, dito naman there is a liability because nagkakaroon ng default bago pa man yung particular events. For example, X, Y, and Z solitary debtors are obliged to deliver to C a specific monkey. Consider the following situations. For the situation number 1, the monkey daw was struck by a lightning. No? The monkey was struck by a lightning. This example refers to the scenario number 1. So without the fault or liability siya kasi the scenario hindi naman totally kasalanan or ginawa ng isang tao. The scenario is an act of nature. No? For the second example, through X fault, the monkey was killed. No? Since it's solidary debtors, pwede maningil si C kay X, Y, and Z, pero pagdating sa mga reimbursement, ang pagbabayad lang ng damage is si X lang. Kasi siya yung may fault. Ang babayaran ni X and Y ay yung kanilang share lang. Example, yung value ng monkey is 9,000. So plus the 1K damages. No? Si X will pay the 3,000 pesos plus the 1K damages kasi yung may kasalanan. But for Y and Z, 3K only kasi wala silang kasalanan. No? For the number 3, no? Example, when the obliged was due, C demanded delivery, but no one was able to deliver the said monkey. After a few days, the monkey was struck by a lightning. This example, no, sila lahat may kasalanan. So lahat sila magbabayad ng value ng monkey, which is the 9,000, hati-hati sila, plus the 1 cage, 1,000 pesos na damage. No? Equally ang paghahati nila. For the Article 1222, a solidary debtor may in actions filled with creditors avail himself of all defenses which are divided from the nature of the obligations and to those which are personal to him or pertain to his own shares. With respect to those which personally belong to the others, he may avail himself, therefore, only as regards that part for which the latter are responsible. Now, so ito naman sa Article 1222 portrays na ito yung mga defenses sa solidary debtor. So in action filed by the creditor, avail himself of the defenses. Okay, in this Article 1202, ito naman yung mga differences ng solidary debtors. In action filed by the creditors, avail himself of all differences. What are those differences? Now, the differences deliver from the nature of the obligations. So meaning to say, complete depends because it nullifies the obligations, it renders the obligations and effective. For example of this are the fraud, the prescriptions, the terminations, illegality of or absence of considerations. The number 2 defenses would be the defenses personal to the debtors. For example of this as affiliated, consent, in the capacity to give consents like yung minor or non-fulfillment to the debtors. The number 3 defenses are the defenses personal to the other solidary debtors. These are the partial defenses. The first and second, that is the complete defenses, meaning to say na yung defenses mo ay napatunayan mo, hindi ka talaga magbabayad.
Divisible and invisible obligation. From the word itself, divisible obligation. Example, to deliver 200 kilos of sugar. Invisible obligation. Example, to deliver a specific car. Legal indivisibility. Pag ang batas mismo ang nagsabi na ito ay invisible. Conventional invincibility. Ito naman ay pag nasa kasunduan o argument. Natural invincibility. Pag ang nature ng object is not admit of division. Article 1224. Pag joint indivisible obligation yung object ng obligation is invisible and yet ang parties are really bound jointly. Article 1225. Ang article na ito, it talks about the rule para ma-determine natin kung divisibility or indivisibility.
Divisible and indivisible obligation. Second paragraph po tayo. The second paragraph tells us if the things to be done can be measured by the number of days of work, by measurement, by metrical units, or by their things, which by the very nature of things establishes the fact that can be performed partially. So now this paragraph tells you that the obligation is to be something or the surrendering of the service, then it will be considered divisible if can be accomplished by the numbers of days of work or their accomplishment by metrical unit, because then there is a measure of how can divided the work, and so you treat it as divisible obligation. The third paragraph provides exemption to the natural or absolute indivisible. According to this paragraph, the express provision of the law or the express stipulation of the parties may render what the otherwise physical divisible things indivisible. So, we have here parties treating the divisible object as an indivisible one, and so they bound by the treatment of the agreement, or if the law treat it as indivisible. Let's say for example this, are obliged to deliver 2 boxes of pad paper to B. It is stipulated that the object of the obligation shall be deemed indivisible. Are 2 boxes of pad paper divisible? No. Why? Yeah, the paper clearly divisible. It can be divided, but always remember, if the parties agree to treat it as indivisible, that so be it, because contract or agreements between the parties have the force of the law between them, and they bound by the agreement. Sinasabi sa article na ito na nagkakaroon ng penalty in case na na-prove na guilty si fraud, at kapag hindi nag-comply si debtor sa obligation niya. Kapag sakali daw pong hindi nasunod ang obligation or hindi nasunod yung obligation, ang kaparusahan ay magbabayad siya ng damages and interest, pero babayaran lang daw po yun kapag tinanggihan ni creditor na bayaran yung penalty, hindi kaya napatunayang guilty yung debtor. Tandaan lang natin ng Article 1226, ang general rule ni obligation with the penal clause is pwedeng isubstitute yung penalty na pamalit bayad sa damages. Pero meron siyang exemption. Ibig sabihin, pwede mo pa rin i-demand yung damages and interest. First exemption, if there is no stipulation in the contrary, meaning walang salungat na napagkasunduan or merong in-express na agreement. Second, kapag na-refuse na debtor na bayaran yung penalty. And last, kapag napatunayang guilty yung fraud si debtor sa pag-fulfill ng kanyang obligation. So next article naman po tayo, which is Article 1227. This is provision penalty. It's not a substitute for performance of obligation. Di pwedeng basta bayaran na lang ni debtor yung penalty instead of performing the obligation. Kaya naglagay ng penalty, di ba? Sabi nga ng general purpose of penal clause is to secure compliance of the obligation. Kung ialaw natin na si debtor na bayaran na lang yung penalty, na di na lang ginawa yung obligation niya, and then nagiging alternative na lang yung obligation, pwedeng ma-exempt yung sarili niya na pagpa-fulfill ng obligation niya kapag meron siyang karapatan na may pakita na proof ng pag-provide para sa kanya. And para mas malinawan pa tayo sa Article 1227, yung next group ko na lang po yung magpapatuloy.
Article 1227. The debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved from him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. Debtor cannot substitute penalty for the principal obligation. Debtor is not allowed to just pay the penalty instead of fulfilling the obligation. He can only do so if the right has been expressly reserved. The reason is that if he can just pay fulfillment of the obligation will be considered an alternative one. The word expressly means that any implied reservation is not allowed. Example, a promises to finish a certain piece of work within 6 months. The contract stipulates that in case he does not build the house at all, he is supposed to forfeit the sum of 1 million pesos. In this case, as a general rule, the contractor cannot just give the sum of 1 million as a substitute for his non-performance of the obligation. It must be remembered that as a general rule, therefore, the penal clause is not supposed to substitute the performance of the principal obligation. He may, however, be expressly granted by the creditor the right to refrain from the execution of the contract by a forfeiture of the penalty. Creditor cannot demand both fulfillment and the penalty at the same time. The creditor does not have this right to demand fulfillment of the obligation and the penalty at the same time. The exception arises when such a right has been clearly granted to him. Next po, Article 1228. Article 1228, proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Penalty demandable without proof of actual damages in an obligation with a penal clause, all the creditor has to prove to enforce the penalty is the violation of the obligation by the debtor. It is not necessary to adduce evidence to prove losses and damages suffered by the creditor or the extent of the same. Indeed, one of the reasons of fixing the penalties to avoid such necessity and other difficulties involves in litigations. The creditor may enforce the penalty whether he suffered damages or not, but he cannot recover more than the stipulated penalty even he proves that the amount of his damages exceeds the penalty. Damages recoverable in addition to penalty must be proved. Article 1228 applies only where the penalty is fixed by the parties to substitute the indemnity for damages. Next po, Article 1229. Article 1229. The judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the courts if it is iniquitous or unconscionable. When the obligation has been partly complied with by the debtor. The first refers to the extent of fulfillment, the latter to the manner. The penalty should be more or less proportionate with the extent of the breach of the contract or of the damage suffered. when the penalty is iniquitous or unconscionable, even if there has been no performance at all. Here, the penalty may be reduced even if there is no performance at all. Even if iniquitous or unconscionable liquidated damages, whether intended as a indemnity or as a penalty, are not void but subject merely to equitable reduction. Article 1230. The nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause. If the penal clause is void, such as when it is contrary to law, morals or good customs, public order or public policy, the principal obligation will remain subsisting. Next po. Obligations with a penal clause. Example, Y is a tenant of X. In their lease contract, there is a stipulation where should Y fail to pay 2 consecutive monthly payments, she will agree to become X mistress. Next po. Vice versa of the first example. Y agreed to become X mistress even if ever wanted to back out from their agreement. Y must pay a penalty of 10,000 pesos.